Communication between solicitor and client for the dominant purpose of legal advice or legal proceedings is privileged and cannot be required to be produced in court. But when does that relationship begin? You might say it begins when the client signs the client agreement. However, often solicitors need to have conversations with prospective clients just to work out what the legal problem is and whether they can help. These conversations might be impossible without the privilege. So the question in this case was this: does client professional privilege arise in communications prior to the actual engagement commencing? And does the privilege remain even if the client then decides not to engage the solicitor? The facts in this case were that a buyer, Taylor, was looking to buy a house to resell for a profit. He went to a solicitor, Priest, asking for a loan of money to form the deposit. Priest asked about the scheme, but when he heard the seller was Minter, he said several defamatory things. It turned out that Priest and Minter had been in previous disputes. Those disputes had settled, but there was still bad blood. Taylor, the buyer, told Minter about the defamatory words used, and Minter sued Priest. When it came time for court, Taylor decided that he didn't want to get in the middle of it and give evidence about the words used, so he claimed that the conversation was subject to privilege. Minter opposed that claim, saying that the conversation couldn't have been privileged because Taylor had not yet engaged the solicitor, and as it happened, he never actually engaged the solicitor at all. The Court of Appeal unanimously found that the conversation was privileged, even though there was not yet fully a relationship of solicitor and client. Justice Greer said, "I do not myself think that any question of privilege, whether it be a privilege of non-disclosure or a privileged occasion within the law of libel, can depend on whether negotiations result in retainer or do not result in retainer. It cannot be that communications which would be privileged if the negotiations are successful are without privilege if they are unsuccessful." From this case, we derive the rule that the protection of client confidentiality starts as soon as the client begins to consult with a lawyer for legal advice, even if they never actually become a client.